On June 29, 2023, the Supreme Court decided that Harvard College and University of North Carolina violated the Equal Protection Clause of the 14th Amendment for conducting race-based admissions. Greater disadvantages are believed to be created to the applicants of color. To balance out the negative influences, on July 3rd, activists filed a federal civil rights complaint against Harvard College over legacy admissions with the U.S. Department of Education's Office of Civil Rights. In this series, we will be in conversations with two education policy professors from Georgetown University to look at the future of racial equity in the U.S. This is TANTV Talk, a platform for conversations that matter. We will be right back. So, hello and welcome to TANTV Talks. My name is Tina Zhang, Senior Editor at TANTV. I'll be in conversation with Professor Janel George, Associate Professor of Law and the Founding Director of the Racial Equity in Educational Law and Policy Clinic. Today, we will look into racial equity in education and how it will be influenced by the Supreme Court's affirmative action ruling and the lawsuit over legacy admissions at Harvard. Hello, Janel George.
Hi, Tina. Thanks so much for having me.
Thank you for coming, Professor George. Shall we start with why affirmative action is important?
Sure. So, Tina, I first think it's important just to recognize the 25 Harvard student and alumni groups and the students from the University of North Carolina, Chapel Hill, who fought so hard to continue to have opportunities for students from diverse backgrounds, and who also sought to underscore the importance that diversity brings to their campuses and to foster diversity and inclusion in our country. I also want to recognize the work of the attorneys with the Lawyers Committee on Civil Rights, Asian Americans Advancing Justice, and the NAACP Legal Defense and Educational Fund, who all worked so hard to uphold 45 years of precedent. So affirmative action is important for quite a few reasons. First of all, as I just noted, the court has recognized for almost half a century the importance of affirmative action. President Johnson in the 60s issued an order ordering the federal workforce and federal agencies to take affirmative action to promote diversity within the workforce. And so that's what triggered efforts to diversify, to expand opportunities to so many people of color who have historically been denied those opportunities. And so affirmative action recognizes really the centuries of denial of educational opportunity, exclusion of people of color. And I will argue that it's at root, it's about anti-Blackness, because I believe that if you really look at our nation's history, what you see is the weaponization of education, the denial of education to impose upon or maintain second-class citizenship for Black people. And of course, that impacted other people of color as well, but at its root, it is anti-Black. So if we look at the laws, actually, when it was codified into law, denial of educational opportunity through what were known as slave codes, which imposed penalties, including death. Georgia did have a provision for Black people, enslaved Black people, enslaved and free, actually, who learned how to read or write. We look at the Black codes that followed in the wake of the end of slavery, and the Black codes prescribed limitations on the movement and actions of Black people. Then that was followed by Jim Crow, which it really, again, to impose second-class citizenship on Black people, relegated them to inferior facilities, and that was recognized and upheld in the doctrine of separate but equal in the case of Plessy versus Ferguson. And Brown versus Board of Education in 1954 dismantled that regime, that apartheid regime, that regime that sought to maintain second-class citizenship of Black people. And so what these decisions do, the UNC and the Harvard College decisions do, is distort Brown versus Board of Education and what it stood for. It's really revisionist history, particularly if you read Justice Thomas's concurring opinion. And it distorts Brown's admonition of the use of race to deny educational opportunity. And instead, what they try to do is decry any mention of race at all. And that is just, I'll take the phrasing that Professor Myron Orfield used for another ruling, Milliken versus Bradley. I would say that's doctrinally dishonest. It is not consistent with legal precedent, and it distorts and denies our nation's history of educational denial. Diversity is vital to a functioning multiracial democracy. The social science research demonstrating the benefits of diversity, not just for students of color, but for all students, is profound. And that dates back to the social sciences brief, the friend of the court brief, that was issued in the Brown versus Board of Education case. It was included in the United States brief in favor of the Brown plaintiffs that was filed in the case as well. And so what this ruling does is it will deprive so many people of opportunities to benefit from diversity.
I see. Yeah, definitely. So will there be any legislative change at the federal and the state level in reaction to the Supreme Court's affirmative action ruling?
So first, Tina, I do want to clarify the scope of this ruling, right? This ruling is limited to the college admissions programs at the University of North Carolina, Chapel Hill, and Harvard College, which use race as like a tipping point in making their admissions decisions. To your question about whether or not these could lead to any state legislative changes, I think what we have to do is situate this coordinated campaign, because that's what it is. So conservative activist Ed Blum brought this case. I do want to point out Students for Fair Admissions was an organization that he created. He had no plaintiffs. There were no named plaintiffs in this case, couldn't find any. Created this organization and later was able to secure a few members for this organization. But this is part of a larger coordinated campaign. Bloom also orchestrated the attacks on voting rights in Shelby County. So we have to situate these two cases within a larger campaign by the right to nullify the voice and the strength of a multiracial democracy. That's what it's really about. And this has been in the works for decades. What they're starting to do is see the fruits, if you will, of their labor. And just as I mentioned that affirmative action efforts were triggered by action at the federal level, I think what we saw with Trump's issuance of an executive order prohibiting diversity trainings in the federal workforce, what you began to see, even though I want to be clear, that order was not only rescinded by President Biden upon taking office, that was actually invalidated by a federal court that placed an injunction on that order to prevent its enforcement. But this is so similar, that issuance of that executive order was similar to like the signing of the Southern Manifesto by members of Congress that triggered state legislative action in the form of massive resistance following the Brown ruling. So that, and even though that order was invalidated, all of this, what I call copycat state and local legislation, you see, borrows directly from the language of that executive order. That's all the anti-critical race theory legislation, all the legislation prohibiting discussions about race or inequality, prohibiting any mention of the history of racial inequality in this nation that will make any student uncomfortable. And we know that that's not really for any student. We know that that's referring to white students. So I think that if we situate these decisions within this larger context of this coordinated attack, I do think that there will be people who, even though this ruling is confined to these 2 college admissions programs, I do think people will take the ruling and try to distort it to discourage diversity efforts in a variety of ways. And I think that will be consistent with these attacks and distortion of critical race theory and other efforts as well.
I see. Yeah, I get it. So it's not about what legislations is going to come out. It is a profound influence to just produce languages and the voices for the right to get back to the area with less racial equity, like overall.
Well, right. And I think it's to nullify the voice and the power of a multiracial democracy. I think that's the overarching goal, is to prevent the inevitability of a multiracial democracy. And I think that that's why these kind of legislative efforts, the anti-CRT, the limiting of discussions of racial inequality in the classroom, are also accompanied with efforts to limit voting rights or to disenfranchise people of color.
I see. So moving on to the other lawsuit, the activists who filed the lawsuit against Harvard aimed to offset the negative impact of the affirmative actions ruling. However, we noticed that there is discourse on the internet pointing out that legacy admissions will mostly affect selective universities, which are already very accessible for privileged groups. So the change of legacy admissions will only have minimal impact on students of color. What would you say about this statement, and shall we focus more on the admissions at non-selective universities?
Well, I think that, again, is because this is part of a coordinated attack. There was the Harvard College and UNC Chapel Hill were purposefully chosen, right? You have a public and private institution. You have these more selective schools that were chosen, I think, in the hope that if you attack the more selective ones, all the other ones will get in line, right? So what I want to emphasize is that students of color, Black students, belong at all universities. And so I think that it's imperative that all institutions of higher education act immediately to ensure that all students feel welcomed and valued. I think it's important that institutions of higher education continue outreach efforts, continue pipeline efforts to ensure that students of color are aware of and understand the processes for admission, that they understand, hey, there are these opportunities. And then I think, again, in a multiracial democracy, all students deserve to feel valued, right? They all deserve to be able to pursue their dream schools, right? And so I think it's important that institutions of higher education continue that outreach, continue to ensure that all students are aware of their opportunities, and then once they're on campuses, that they feel welcome and included. That was my experience. I'm a graduate of a historically Black college and university, and I recognize the value of HBCUs. However, I think it's also important to recognize that, again, students of color belong at all schools. HBCUs were in part a response to segregated education, and they were designed to create educational opportunity where it was otherwise denied to Black people. And so I think HBCUs serve a very important function And I think that all students, Black students and other students of color, deserve to have educational opportunity wherever they want to go. So, for example, I went to a HBCU, but I went on to law school at a predominantly white institution where I actually did feel very included, where I did feel that the administration and the staff made efforts to not only recruit Black students, but ensure that once we were there, that we felt welcomed and that we had the support that we needed to succeed. And I think it can be done. I think it must be done, and that's really important. And again, if we see the legacy of this, what I think what history will tell us, Tina, is actually that these cases will be part of that progeny of inequality, the way that education has been weaponized. I mentioned the slave codes, the Black codes, Jim Crow, these decisions seeking to advance exclusion. And again, the weaponization of education that are progeny of these efforts to relegate Black people to second-class citizenship. That's what W.E.B. Du Bois called caste education. That's what this is about. And I think that we have to expose that. We have to acknowledge that. This notion of color blindness, which many people think is initially, oh, that's a good idea, we don't see color. This is not a colorblind country. Justice Sotomayor talked about that in her dissent. This is not a colorblind nation. All of the things that I just mentioned were once codified into law, and slavery itself was predicated on race. So this is not a country that doesn't acknowledge race. It acknowledges race. And unfortunately, again, I think at root, this is about anti-Blackness. It also weaponizes education in efforts to maintain racial inequality and white supremacy.
I get it. Yeah, given that we spotted that legacy admissions is so important, and still we have to challenge it at any level of universities, would you say that there's any chances for this lawsuit to succeed in the end? And will it be influencing any federal and state level legislation in the future?
Yeah, so that's hard to say. I think we have a federal judiciary, again, as a result of decades of efforts that right now doesn't reflect, I don't think, the values or priorities of so many people in this nation. If you look even at the polling, for example, the majority of Asian Americans support affirmative action. But unfortunately, we have a federal judiciary that's not reflective of that because of various legislative efforts and obstacles. We have many on the federal judiciary, and I do think President Biden has done an outstanding job of diversifying the federal bench, not only through racial diversity, but diversity of background. There have been a few civil rights lawyers who are now in the federal judiciary. So it's hard to say how that case may come out. It's very difficult to say at this point, given the current makeup of the federal judiciary. I do think that there will be state level efforts to, I think, consistent with the anti-critical race theory legislation, to distort this ruling, to discourage diversity and inclusion efforts. I think we will see that. And I do think it's important, again, to underscore that these cases, these decisions, or this decision is limited to 2 higher education admissions programs, and that we should continue diversity efforts at many different levels. One way I think we can promote diversity is also in diversifying the educator workforce, both at the higher education level as well as the K through 12 level. A lot of folks don't realize that one of the effects, unfortunate consequences of massive resistance was a purging of Black educators from the teaching workforce. So many people today look at the dearth of Black educators in the teaching workforce and they say, well, how did this happen? Well, we had a lot of Black educators pre-Brown versus Board of Education in the workforce, and they were actually instrumental in school desegregation efforts. They helped organizations like the Legal Defense Fund, for example, identify plaintiffs. They would say, this is a star student. They come from a great family. This is someone who could be a plaintiff in your case. And I think in part retaliation, and I think there are other scholars like Vanessa Siddle Walker, who writes a lot about this, who would say that they experience retaliation as a result of those efforts. So the way that school desegregation was envisioned is the Black teachers were supposed to be integrated along with the students. It was supposed to be two ways. The Black educators and students were going to go to white schools, white educators and white students were going to go to Black schools. That's not what happened. Instead, and again, in part, I think in retaliation for their desegregation activism, Black educators lost their jobs. Black principals, and again, these folks, many of them were way better educated than their white counterparts. Principals were demoted to be bus drivers. One scholar notes that in the years immediately following the Brown ruling, over 38,000 Black educators across the South lost their jobs. So there was this purging of Black educators from the workforce, right? And so I think when we talk about school diversity and we talk about fostering inclusive environments, it's also important to ensure that the teaching workforce reflects the diversity in background and experiences of the student body as well. And I think that that's one excellent way to create a pipeline to foster those kind of inclusive and welcoming environments. And I think it's a very overlooked way to remedy again, a very overlooked consequence of massive resistance to school desegregation.
Since we touched about teachers, so people are now suggesting that the government should train teachers to better inform high school students of color to sort of get familiar to the university application tactics and career search tactics. So how much do you think this is helpful and how can we make it possible?
So I think that's extremely helpful, but I would actually say it starts way earlier than high school. I think it should start at the elementary school level, where we normalize students going on to higher education or to career, whatever their preference is, whatever they as individuals want to pursue. But I think it's really important that at an early age, students of color understand the opportunities and the options. And it's important for not only the students, but their families to understand what the processes are. I think that the admissions process can be intimidating, particularly if you have parents who haven't pursued higher education. There are critical deadlines. I've heard from other students who have missed application deadlines. The federal financial assistance deadlines, and then they're unable to pursue higher education opportunities. So I think demystifying and democratizing the application process, what are key deadlines? How do you get financial aid? How do you get support? How do you apply for scholarships? All of those things are very vital to teaching students and their families about very early. And again, I think earlier than high school, start in elementary school. And so when they go on to middle school, they understand what are some of the prerequisites, which, by the way, many under-resourced schools and many students of color are relegated to, don't always provide those prerequisites. So again, how do we expand opportunities so that all students are equipped and set on a trajectory to be able to access those higher education opportunities? That's very important as well, right? Because it starts way before high school.
I see. So what else can we done to sort of relieve the negative impact of the affirmative action ruling?
I think it's important to underscore again the limited scope of the ruling that's focused on these two school admissions programs. I think what we just talked about in terms of creating a pipeline for students of color early in elementary school. I think getting more resource equity in schools so that students of color are attending schools, again, at the elementary, middle school level, where they have the opportunity to take the advanced placement courses, where they have the opportunities to participate in extracurriculars, all of those things that will help put them on a pathway so that they can pursue and be competitive for these higher education opportunities. It's not because what we see in many admissions or exclusion from many of these admissions programs, it's not because students of color are less intelligent, and that's the prevailing narrative that's rooted in white supremacy and stereotypes and inequality. It's about opportunity. So opportunity in middle school levels, opportunity at high school levels, opportunities in access and preparation so that they are equipped and exposed to the opportunities that will prepare them for these different higher education options.
Yeah, for sure. I also learned about like what the critical race theory that you mentioned before, like in your previous interviews, which is very illuminating. You addressed that there are internalized systematic and social constructed hardships for students of color. So what are some other examples of law and policy that perpetuates racial inequality, and what can we do to solve them?
Sure. So critical race theory it originated in the legal academy by Derek Bell and others, including one of his star students, Kimberly Crenshaw, Richard Delgado, Gene Stefancic, and other scholars, Mari Matsuda and others, who recognized that the law in many ways could reify racial inequality. And it's a theory, it's really an approach. As Crenshaw notes, it's a verb, not a noun. It's a way of looking at the law to see what is its potential for either entrenching or helping to eradicate racial inequality. So one way, and Tina, I just mentioned about school resources. But if we look at school funding and the way that many states and localities set up their school funding systems, for example, in many jurisdictions, school funding is based on property values. But if we look at the history of racial inequality, there were practices such as redlining, in which unfortunately government actors as well as banks and mortgage lenders were complicit in relegating people of color to communities to which they ascribed lower property values. So even if people of color in those communities tax themselves at a higher rate, if you are conditioning your education funding on property values, you're not able to generate enough revenue to fully fund education in the way that a predominantly white community that has historically been ascribed a higher property value will be able to do. And unfortunately, in 1973, in the case of San Antonio versus Rodriguez, the U.S. Supreme Court said differentiation in education funding, even if it fell along racial lines, if it was not it wasn't a constitutional infirmity. It wasn't a constitutional issue, right? So you had the San Antonio, you had communities of color, predominantly Mexican American, that were not able, again, even though they tax themselves at higher rates, were not able to generate high levels of revenue to be able to get the quality school facilities, the course offerings, et cetera, that the neighboring predominantly white community was able to do. And again, we have to see this in the historic context, and we have to see how the discriminatory policies created conditions of inequality. And when we predicate things like school funding And these laws seem totally neutral, right? If you look at them, it doesn't seem like, oh, this doesn't seem inequitable. What's wrong with basing school funding on property values? But unless you understand that history and unless you understand that context, you're not able to recognize how conditioning education revenue on property values, which again were predicated on race, actually perpetuates inequality. So that's one way. For example, the critical race theory, applying that critical race theory lens and analysis helps us to see how inequality, unfortunately, is entrenched, right? So again, if you don't have the advanced placement courses, if you don't have the extracurriculars, you will be excluded. In some places, like in New York State, you could be excluded by like 7th grade for admission even to selective high schools, right? And so it's seeing how these otherwise would appear to be neutral laws really entrench and replicate racial inequality. So we have to start unraveling that and then recognize, well, what are other means? How can we equalize, if you will, education funding so that we ensure that all students have equality of opportunity?
We've covered all of our questions. Professor George, do you have any last words you want to add to this?
I really want to emphasize the need for a sense of urgency. I think so many of us have become accustomed to the status quo of inequality, but there is a lot at stake. And I don't think it's being overly dramatic to say the future of a viable multiracial democracy is at stake. And I think that a lot of folks on the right are undermining it through the weaponization of education. But that's nothing new. They've done it before. And because they've done it before, we also have to recognize what has worked. For example, federal action to protect opportunity and enshrine opportunity. That has been done before. The federal government, in the wake of massive resistance, Congress acted to pass the Civil Rights Act of 1964, the Education, Elementary and Secondary Education Act of 1965. The executive acted to rescind federal funds, and that did happen to many non-compliant Southern school districts. That's what helped to bring massive resistance to its knees. And so we see these different iterations of white supremacy and the weaponization of education. And we have to likewise, just as white supremacy is really persistent, we have to likewise be persistent and creative in the remedies and the supports that we provide to communities of color to protect and expand educational opportunity. So we have to be vigilant. We have to be persistent. I think there's a profound role that the federal government can play on many different fronts to address this, and that could be provide more provision of federal funding. I just talked about school funding inequities and how many local school funding laws are inequitable in their nature. Perhaps we could have additional federal funding to localities that have been historically underfunded. And I'm not talking about predicating that on racial demographics. I'm talking about looking at historic patterns of underfunding in communities. And so I do think that again, we've seen this before. There's nothing new. We have to expose it. We have to be vigilant, and we have to act.
Thank you so much, Professor George, for this conversation. It's highly educational. It's very important for the Black readers of TANTV to learn all this about history and what we should do in the future. Yeah, definitely very helpful. Yeah.
Thank you. And again, thank you for having me.